Good morning and welcome to the Law Show. Bob Kerrigan with you this morning as we talk about the law from the law firm of Kerrigan, Estes, Rankin, McLeod, and Thompson. Website there is behind me, Kerrigan.com, Kerrigan.com. You can access a lot of information on our website about various kinds of cases, and our Google reviews are on the website, as well as many of the YouTube films that we have, or YouTube postings that we have, and all hopefully helpful to you in the event that you're trying to determine what to do where you've had a catastrophic injury, a death, or a loss that you are trying to get some legal help for. Law firms represent cases involving injury and deaths generally on a contingency fee basis, and that means a percentage of the amount that is recovered. You should never agree to pay a lawyer to pursue a claim when you're making a contingency type claim. It's not appropriate for the lawyer to charge anything unless a recovery is made. The lawyer might propose it to you, but certainly don't do that. There are many, many lawyers, fine lawyers, that would agree to undertake the case for a percentage of the recovery. That's very common. The Florida Supreme Court has promulgated a suggested contract. That's a contract we generally use involving injury or death claims. That contract is available on our website, or if you want to have a copy of it or whatever, if you'll call us, we'll be glad to send it to you. It provides the various aspects of the case and what costs are and fees and that sort of thing. Costs can be very deceiving. For example, costs from our firm are those things that we have to pay for to help you in your case. That is expert witnesses, medical reports, documents, certain kinds of materials that we have to subpoena, the cost of getting those materials. Our general overhead, however, that is what we pay our staff and our rent and utilities and the kinds of expenses that all businesses have, are not subject to be paid back to us by the client. Only our out-of-pocket costs, what we've actually had to pay for to help advance the client's case. So do not be very leery of a contract that has provisions in it that require you to pay any portion of the firm's overhead, salaries or anything like that. Very, very suspect if that's presented to you. I'm going to go over now the statement of clients' rights, which are rights that the Supreme Court of Florida has said that you have, and that we want you to know what those rights are when you consider hiring a law firm to prosecute a serious case. I will say, and I've said this before in the law show, we don't file frivolous claims. We don't file claims just to get a settlement. We don't threaten people just to get a settlement. And this is a somewhat amusing story. Years ago, my partner, Bill Rankin, had a client that came to him, a prospective client, and said, "Mr. Rankin, I'd like you to write a letter to this company and tell them that they should pay an amount that was in dispute." And he said, "Well, how much will you charge me to write that letter?" And Mr. Rankin said, "Well, I'll charge you $5 to write the letter." And he said, "Only $5? That's all you're going to charge me?" "Yes, I'm only going to charge you $5. Now, if you want me to sign the letter, that's a whole lot different." So when a lawyer sends a letter indicating that they're going to make a claim, or that they're intend to prosecute a claim for somebody, it better be serious and not just a threat. We don't make threats. We may write to a potential defendant in a case and say, "You have an opportunity to settle this case for a reasonable amount. Here's what happened. Here's the nature of the damages that have been incurred. And here's our theory of why your company may be at fault or may be responsible for this." But we don't do that with a hope of making a recovery and then drop the client like a lead brick, or this, I guess bricks aren't lead, but you drop the client like a cement block, I guess. In the end, if the case doesn't settle, we don't do that. If you make a demand and you ask for a recovery for your client and it's not paid, you have to be prepared to file the lawsuit. And lawsuits only get filed where cases cannot be settled. But there are lawyers, and you don't want to find yourself in this situation where the lawyer will write a letter and hope to get some kind of recovery for the client. And when they don't, just tell the client, I'm sorry, that's all we can do. So you need to ask the lawyer, when you retain the lawyer, are you going to represent me through the case, to the conclusion of the case, all the way through a jury trial? Are you prepared to do that? Now, here's some other questions that the Florida Supreme Court has recommended that you ask lawyers, and the rights that you have in dealing with lawyers. And so I'll go over some of these for you. Now, they're available in writing, by the way. If you want a copy, you can contact us or go to our website, which is on the screen behind me, Kerrigan.com. Bob Kerrigan with you this morning. On the Law Show, we're here every Sunday morning. Hope you'll join us and send a text to us at any time during the show. Our text number is 850-444-4444. That is the firm phone number, but to text us, like all text, you have to precede it with 850. So 850-444-4444. For any information that you want that we have or they're disclosed on the program, if you want copies of any documents or you have any questions, you can contact us by text. You can also email us, and the email is bob@kerrigan.com on the screen, KERRIGAN.com. You email me at any time, and we'll try to respond pretty quickly. So let me go through the statement of clients' rights with you briefly this morning. Number one, there's no legal requirement that a lawyer charge a client a set fee or a percentage of the money recovered in a case. You, the client, have the right to talk with your lawyer about proposed fees and to bargain about the rate or percentage as in any other contract. That's a right that the client has. Any contingency fee contract must be in writing. And then if you sign it, you've got 3 days to reconsider the contract. So if you feel after you leave the lawyer's office that the papers have been placed in front of you, and many years ago they used to say that the car dealers, they don't do this anymore, but they had tilted desks. And so when the customer was on the other side of the desk, the salesman would put the pen down there and it kind of fell down towards the customer and they had the pen right there to sign. Well, we don't do that sort of thing anymore, but sometimes lawyers will push the papers on you and tell you, well, you need to sign up, right away, you need to sign up. Well, if you feel like you've been pressured into something and you're giving it second thought, you have 3 days to get out of it, and the lawyer can't charge you a dime unless the lawyer has incurred some costs in that 3 days. For example, if they ordered an accident report or had some other minor cost, then you, in theory, would have to pay them for it. But you have a right after 3 days, up to 3 days, to get out of the contract. One of the mega firms has advertised locally that you can fire your lawyer. They come on TV and say you can fire your lawyer. Well, the irony is that you can fire their lawyers too. So you can fire any lawyer you want to, just be careful. You may be obligated to pay a portion of that lawyer's fee. Generally, lawyers that are discharged will file a charging lien for the work that they've done, and the court settles that out in the end. We never encourage people to fire a lawyer. The lawyer could be busy. He or she could be having personal issues or whatever, not calling you back when you had hoped they would. So we recommend that you really try to work with the lawyer that you've hired. However, if you feel like you're not getting adequate representation and you are dissatisfied with a lawyer and it is hopeless and the lawyer won't communicate with you, won't talk to you, won't answer your questions, you absolutely have a right to discharge a lawyer. You don't have to stay with that lawyer. And in fact, the irony will be you'll end up discharging one of the mega firms for the lawyers, because the problem with the mega firms is you never know which lawyer you're going to get. You get a lawyer and that lawyer could be gone the next day. So that is a right that you have to discharge a lawyer, and 3 days to cancel that contract. Before hiring the lawyer, You, the client, have the right to know about the lawyer's education, training, and experience. Pretty basic, isn't it? You wouldn't let a doctor operate on you that you didn't know anything about what they had done or what training they had or what certification that they had. All the partners at Kerrigan, Estes, Rankin, McLeod, and Thompson are board certified. That is, we're specialists in the field that we work in, and we all have extensive experience, decades of experience doing this kind of work. And we work on the cases like a team. We're constantly communicating with each other and trying to see what is the best avenue that we can devise for the client for the particular case that we have. Before signing a contingency fee contract with a lawyer must advise you whether the lawyer intends to handle your case alone or whether lawyers will be helping with the case. That's true. And they also have to tell you, because there are many lawyers that advertise, and as soon as they get the case, they refer it to another lawyer. Well, why would they do that? Well, sometimes they do it because they are only advertising lawyers. They don't actually take cases themselves. They don't prosecute cases. They just get fees. What kind of fees can a lawyer get by just referring the case to another lawyer? Well, up to 25%. And so there are people that advertise to get cases simply to send them to other lawyers. And then they get a percentage of the fee, up to 25%. They're obligated to tell you if that's the plan. And if that's the plan, get out of that lawyer's office and go to whoever they're going to refer you to and talk to that lawyer, because they're probably going to refer you to somebody that knows what they're doing. And all they're doing is scraping off 25% of a referral fee. You, the client, have a right to know in advance how you will need to pay the expenses and legal fees. As I say, with our firm, you don't pay a dime unless we make a recovery, and you don't have to repay costs that we've incurred unless you make a recovery. For some reason the case goes bad, we don't make a recovery, and we hope that's not the case. That's very rare, but if it is, then you don't owe us a penny for the cost that we have incurred. You, the client, have a right to be told by your lawyers about possible adverse consequences if you lose the case. There are situations where you might be exposed to fees or costs if you lose the case. A lawyer should discuss that with you. You have a right to receive and approve a closing statement. This statement should explain to you in great detail how much the lawyer is charging and what kind of costs have been incurred, and then what you are going to net. You have a right to ask the lawyer in reasonable intervals how the case is progressing. Lawyers should communicate with you, not just through their staff, but the lawyer themselves should be communicating with you. You, the client, have a right to make the final decision regarding settlement of a case. Most clients will say, what do you think? We give them our advice, and then they make up their mind based upon the advice that we give them. If they don't ask us our advice and they kind of know what they want to do, then we don't give advice. Lawyers give advice. We don't make decisions for people. You, the client, have a right to make the final decision regarding all aspects of the case, whether it's going to go to trial or not. If at any time you, the client, that your lawyer has charged an excessive or illegal fee, you have a right to report to the matter to the Florida Bar, and you can call us and tell us and give us a copy of the distribution documents that disclose how much the lawyer has charged if you think it's been excessive or the lawyer has charged you for things the lawyer shouldn't charge you for or whatever. We'll review that at no cost and no charge to you whatsoever, just to assure that you've been properly treated and properly, the case has been properly concluded. We'll be back with more of the Law Show in just a minute.
For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida.
Welcome back to the Law Show. Bob Kerrigan with you this Sunday morning. Thank you very much for joining us and participating with us in the Law Show, which you do by sending your text messages to us, which we answer during the show. 850-444-4444. That's the firm number throughout North Florida, and that's all fours. For Kerrigan, Estes, Rankin, McLeod, and Thompson. We are board certified specialists in matters involving serious injury or death claims, and we've done this for many, many decades. Board certification in Florida is a small percentage of lawyers. They used to say it was 1%. I think it may be a little bit higher than that now. But it requires a number of hurdles that you have to jump over, including your background, your experience, reputation with the courts, with your fellow lawyers, and you have to take a rigorous examination in the field, and you have to pass that examination. And then you have to be recertified every 5 years. We have to go back to the certification board of the Florida Bar and fulfill our obligations to stay informed and to be abreast of the law that is involved in our area. And that requires attending continuing legal education courses and being on top of what the law is. The law is dynamic. It's changing regularly, unpredictably sometimes, and it can have a profound effect on the ability of the lawyer to make a recovery. These cases, the serious injury cases and accidental death cases, are complicated. They are generally complicated. They take a good deal of time and resources in terms of investigation and preparation and research and that sort of thing. And you need to have lawyers that are familiar with what they're doing, have handled a number of these cases, and have a degree of specialization. You would not want to hire a doctor or an accountant or any other professional person that just said how good they were when they advertised, and you would want to probe that with some interest. Problem is with lawyers, it's so hard to differentiate among lawyers, and invariably, and I know nurses will tell you that sometimes the best doctors don't have really good bedside manners, and sometimes the worst doctors are just Mr. Congeniality. So it's hard to know how to talk to lawyers and how to make a proper selection or decision regarding a lawyer. So we encourage people to ask lots and lots of questions. And before you just hire one of these mega law firms or somebody that's on TV every night, please call us and talk to us. There's no obligation at all. And we'll tell you about our background and experience. We don't say anything negative about other law firms or other lawyers when we talk to clients. I'm just saying now, generally, there's some problems out there. And it's obvious when you see the kinds of advertisements that are taking place now. And as I've talked about on this show before, the public doesn't like it, the judges don't like it, and it's really hurt the image of lawyers. I think that some of these ads are just obnoxious. And that's no way to pick a lawyer to handle your case, because that lawyer has to navigate through the legal system. And the legal system, it consists of judges and juries and others. And if you have a reputation of just doing bad things on TV, it hurts the client's case. So think about that. And as I say, there's no obligation and no charge for us to talk to you about your case. I want to talk today about something that a viewer has asked about. Good question. They want to understand what this grand jury business is all about. State grand juries and federal grand juries, they're a little different. Federal grand juries are a little bit different. But I'm going to go over the structure of grand juries in Florida. And I want to credit Greg Thomas, Carol Jean LaCicero, and Linda R. Norbutt, who wrote a wonderful article for the Florida Bar Journal many years ago, I think, and I'm not sure the exact date when this was published, but it's a good summary. It's a good overall guideline as we go through the discussion. So I'll be referring to this from time to time, but I want to give credit to the people who wrote this. The grand jury is not that the grand jury system is not that complicated. And here's a big picture difference in grand jury and petit juries, that is, juries that would decide criminal or civil trials. A grand jury is picked, the members of the grand jury are picked by the prosecutor. Okay. So that's all done in a way that the public's not involved. This is done in a way where the prosecutor goes in, there's a panel of people, and the prosecutor picks these people. And they serve on the grand jury, I think, for up to 6 months. I'm not sure exact time, but around 6 months. And they'll handle cases or address matters that the prosecutor presents to them. In Florida, the grand jury can actually investigate other matters that are of community interest. I'll give you an example of something I was involved in as a young public defender. We had young men that were sentenced to the road camp here in Escambia County. And when they got to the road camp, they were treated very badly. And it was an awful situation at that road camp involving the way the guards treated everybody. This was 40 years ago. And so I was getting this information. I was a public defender. I was representing people, and I was hearing about things of putting young boys into confinement with a known violent criminal that would assault them. And we had cases in which the food that they were fed was so bad, baby food, that their teeth were falling out, things like that. It was awful, just terrible abuse and punishment. But taking place right here in this county. So I went to a prosecutor and asked the prosecutor to look into it in terms of presenting it to a grand jury, see what could be done. That was very foolish. I shouldn't have done it. I should have filed suit immediately and not trusted the system. The system was unable to deal with it adequately. It was investigated. There was a grand jury report, but it was all basically covered up, and nothing really happened of any consequence. As I say now, what I would do, hearing things like that, I would immediately file a lawsuit and get before a judge and get information as fast as possible in the case. But that grand jury conducted an investigation of some kind about the circumstances at this road camp. These guards, in my opinion, should have been criminally prosecuted. They weren't, and nothing really happened about it. But that was a function of the grand jury, and still is a function of the grand jury, to conduct investigations that the prosecutor gives them. It's generally, I think, 15 to 21 people are on the grand jury, and whereas a normal trial jury is 6 people generally in Florida, in the state courts I'm talking about now, and up to actually 12 people are required for a capital case, and that's a case in which the state is asking for the death penalty. You have to have 12 jurors. The grand jury returns indictments or not, whatever they desire. It's all done in private. It's all secret. It's not open to the public. And the grand jury makes a decision whether a formal criminal prosecution should take place. Now, the grand jury has to make a decision regarding a capital case. They must return an indictment before a person can face the possibility of losing their life in a capital case. But grand jurors, in my opinion, many times the grand jury is used as just kind of a cover for the prosecutor, who doesn't want to take a lot of political heat for making a decision not to charge somebody. The prosecutor has the right to charge a person directly with an information. That's different than the federal grand jury, but in the state grand jury, in the state prosecution system, the prosecutor has a right to charge a person directly, and that's called by information, which is really the document of the charging document that they're accused of a crime. They don't have to go to a grand jury for anything except a capital case. But they do go to the grand jury, and we've read about it, and we've seen it, and the grand jury is going to consider this, and the grand jury is going to consider that. I think it can be abused. I'm not suggesting it has been, but I think it can be abused by prosecutors. They should just, in my judgment, many times just make the decision, go ahead and charge somebody or not charge somebody. But then on the other side of that, in fairness to the prosecutors, many times they'll say, well, we want public input. We want to know what the grand jurors think. It's our community. We don't want to just jump up and charge somebody to appease people who are clamoring for a criminal charge. And I think that's a legitimate argument. There's arguments for and against it, so I'll give you both of them. After the evidence is presented, the grand jury decides whether there's a probable cause to indict. That's all they decide, is their probable cause. That is a basis, in fact, to believe the crime has been committed, and then they return an indictment. It's identical to an information in that it is just a charging document. An indictment comes from the grand jury. A charging document called an information comes directly from the state attorney. People appearing before a grand jury are absolutely privileged from any liability or any possible claim against them for any testimony they provide to the grand jury. The grand jury can also issue reports, and if they issue a report, the person that they've issued their report about, like an individual or a circumstance that involves several people, I've had one of those cases as well. The person that is implicated by the grand jury in maybe wrongdoing or a negative exposure of some kind, they have up to 15 days to file a request to redact or eliminate some of that report so that it does not become public, and then a judge will make that determination as to whether or not it's public. You're listening to The Law Show. Bob Kerrigan with you. We just took on some subjects that our listeners have asked about and wanted to know a little bit more about. And this is, what is this grand jury business all about, and how does it differ from state petit juries? This article concludes that nevertheless, the grand jury is in essence the prosecutor's mechanism. In large part, the prosecutor is the only official present. That was one of my many observations about the grand jury process. However, I had a case many, many years ago, and now the prosecutor at the time, who's now a federal judge, my client was accused of murder, and yet I was convinced that the overall facts and circumstances were such that he should not be indicted. And I had the greatest confidence in this prosecutor, who's now a federal judge, and only time in my career I had my client go before the grand jury. I couldn't go in. The defense lawyer can't go in. Most defense lawyers will tell you that is a terrible decision. That was an awful decision. You should never have let your client go before a grand jury. Except in my case, I trusted this prosecutor as an honorable person, and they returned a no true bill. My client was never charged with the murder. It was clearly a case of self-defense, and it was the right decision by the grand jury. That grand jury was listening to the case because it involved a murder charge, and if the grand jury was going to return an indictment for first-degree murder, I didn't want that to happen to my client without the grand jury knowing what really had happened, that they might not have known otherwise. And so he went in and testified before the grand jury. We'll cover in a subsequent broadcast how the federal grand jury works, but in summary, the state grand juries conduct investigations involving criminal offenses or other community issues, can issue a report or an indictment. They do it privately, in secret. They don't have to disclose. The jurors don't disclose what they've heard in the grand jury. A witness who testifies in the grand jury in the state system can talk about what they told the grand jury, but that has to be done after the investigation or charges have been completed. Bob Kerrigan with you with The Law Show. We're going to take a short break here, and we'll be back. Contact us at Kerrigan.com.
Looking for the number of an experienced personal injury lawyer? Look for our number. You'll see it everywhere. Kerrigan, Estes, Rankin, McLeod, and Thompson. May the fours be with you. Looking for the number of an experienced personal injury lawyer? Look for our number. You'll see it everywhere. Welcome back to The Law Show. I'm Mike McLeod, and I'll be with you for this segment of the show. Again, the Law Show is brought to you by the law firm Kerrigan, Rankin, McLeod, and Thompson. Our firm specializes in cases that involve serious injury and accidental death. The Kerrigan Law Firm has been around for 40 years in Northwest Florida, representing people who've been seriously injured and helping loved ones who've lost other loved ones in serious accidents. You can text us at our phone number, 850-444-4444. It's the easiest number around. It's our office number, but also you can text me during the show and we'll try and get you a reply, and we'll try to answer your question if you have them as a result of what you hear on the Law Show this morning. And also, my email address is mike.mcleod, and it's MCLEOD, mike.mcleod@kerrigan.com. So if you have a question that you want us to address on the Law Show, or if you want to email me about a comment or a question as a result of what you hear on the Law Show this morning, I'd be happy to respond by email. In our cases, there is, of course, no fee unless there's a successful recovery for our clients. And I want to talk this morning some about our most common cases. Our firm represents people who are injured in a lot of different ways, but obviously most of the cases that we deal with are automobile accident cases. So during this segment of the show, I want to talk some about car wreck cases. And I think the first question to address is, do I need a lawyer after somebody hits me and it's their fault, it's not my fault? Do I need to call a lawyer? And in a lot of accidents, there's property damage. You may have your car totaled, but if you're not injured, if you don't have symptoms, or I think if you have modest symptoms that you think are going to disappear in a day or two, I don't think you need to rush to call a lawyer, and we've never encouraged that. If you have more serious symptoms, for example, if you have broken bones, if you've been referred by the emergency room to other physicians, if you left the scene of the accident in an ambulance and you have continuing painful symptoms and you've been referred to other doctors, then I think those are cases where a lawyer can be beneficial. And then, of course, some cases people have very serious injuries. We've represented hundreds of cases where people have devastating injuries from accidents and need our help, and we're anxious to get started on those cases that are clearly cases where a lawyer can be beneficial right away. So let's talk about the 4 parts of having a successful case. It really any case generally, but we'll make it particular to automobile accident cases. First, 4 elements. So the first thing is the other person was at fault. And sometimes that is just crystal clear. You're sitting at a red light, you get rear-ended. It's amazing how many motor vehicle accidents are just rear-end collisions where the person behind you wasn't paying attention, was on their cell phone, or was distracted. Or another car runs a red light. Those are crystal clear cases that don't require a lot of investigation and necessarily contacting witnesses, which we do a lot of times. But other cases can be, and we investigate all of these cases fully, but other cases can be more complicated. And in those cases, we do several different things. In many cases, we can hire engineers who can reconstruct accidents from the skid marks that tires leave on the road, from crush damage in the automobiles, and they can help determine how fast a vehicle was going. A lot of times in recent years, we've had drones go up to map the accident scenes in serious accidents if there's a contest about who caused the accident. And then most recently, cars over the last 10 to 15 years all have something called an event data recorder. And it's kind of like the black box on an airplane. So after a serious accident, licensed and qualified technicians can get to this event data recorder, and it's typically in the front part of a passenger car between the two front seats down in under the glove box, not the glove box, but the center console. And technicians can access that and they can download data that's recorded after an accident. And these data recorders can tell us after an accident how fast that car was traveling at the point of impact. They can tell us whether or not the driver had his foot on the, or her foot on the brake at the time of the accident. They can tell us if the driver was accelerating, what percentage the accelerator pedal was pressed at the time of the accident. And they can tell us whether or not the occupants of the front passenger seats of the car were wearing their seatbelt. So kind of years ago, we would have to prove these things through eyewitnesses and witnesses to the accident from various different elements. But today, we can download data that absolutely proves all of these facts: how fast the car was going, the direction of impact, whether the brake was applied or the accelerator, and how much. So this is a kind of a critical new part of investigating complex accidents when it's not crystal clear how the accident happened. Now, the second element is, does the client have a real injury? And so sometimes after an accident, it's just crystal clear. A person has a broken arm, they go to the emergency room, they're referred to an orthopedic doctor. The doctor says, hey, I've got to do surgery to put your bones back together. The client ends up with pins and plates. Sometimes joints are affected that really can persist for a lifetime and affect a person's ability to do physical things. Sometimes people can get tremendous back or neck injuries in accidents, and immediately an MRI exam, which is a sophisticated diagnostic tool, can tell us that a person has a ruptured disc or a herniated disc that's pressing on the spinal column and causing severe symptoms in arms and legs. And so those cases, it's crystal clear early on in the case that the client has a significant injury. In other cases, a client can have persistent symptoms, whether they be headaches, neck pain, radiating symptoms into their arms or legs. And it's because there are no bones that are broken, it's not obvious at the outset how severe the injury is. And so in those cases, to protect the client, we don't get in a hurry. We are patient about their treatment. We wait, hoping that they get better. They follow a doctor's guidelines and care, and hoping that their physicians can make them better. And then at the end of the day, because we don't have an x-ray that shows a broken arm, we often will meet with physicians who are treating our clients to see whether or not the physician it will document that this injury came from the accident and caused our client these persistent symptoms. All right, so let's back up. 1, the other person's at fault. 2, the client has a real injury. 3, we call causation. And causation simply means the accident caused the injury. And so, as we get older, we get just typical aging aches and pains. It's not uncommon for someone in an accident to have pre-existing back problems from an injury or just from life, pre-existing neck problems. Sometimes people have problems with headaches. But when you're in a severe accident, oftentimes those symptoms become aggravated and worsened. And so most people who are injured in accidents aren't Olympic athletes with no problems whatsoever. But in those cases where people have some pre-existing type symptoms, we have to sort out, well, how was the person before the accident and what were those symptoms like? And how have they been worsened? And how are they made more severe by the traumatic effect of the accident? And again, we look typically to the physicians and doctors who are treating our clients to help us sort out, well, how much of an aggravation was this to a client's pre-existing condition? Again, sometimes it's not an issue at all. In cases where people have orthopedic injuries from an accident, it's crystal clear that it came from the accident. But in a lot of cases, we have to sort those things out. So, other guys at fault, client has a real injury, the accident caused the injury, and then the final element is there's a source to pay what the client deserves to be paid to compensate them for what happened to them in the accident. And typically, there's a source of insurance to pay this claim or case. And so in a lot of cases, we spend a good bit of effort looking for various places to make sure our clients are fully compensated. The typical thing is we look to the other person's insurance who is driving the other car. And that's the first place we look. But also, if the owner of the vehicle is different, then not only is the driver of the car who caused the accident responsible and his or her insurance responsible, but also the owner who gave permission to that driver, the owner's insurance policy is also responsible. And then we also look to our clients' own policies to see if they have something called uninsured motorist coverage. So uninsured motorist coverage, and we could spend a whole segment of the law show on this, is coverage that a person buys on their own policy that protects them in the event that they are hit and injured by an uninsured or underinsured driver. And if you have questions about your own policy, again, you can email me at mike.mcleod@kerrigan.com. I'll be happy to reply, or you can text us at our office phone number, 850-444-4444. There are a lot of kind of subparts to uninsured motorist coverage. It applies if you're a pedestrian hit by a car. Sometimes you can add your policies together to double or triple the coverage depending on how many vehicles you have. It's kind of an inexpensive type of insurance to buy. It'd be a great thing for people that are watching the law show this morning to check their policies to see if you have uninsured motorist coverage. So those are the four elements of having a successful case, and particularly this morning, an automobile accident case. Other guys at fault, the client has a real injury, the accident is what caused the injury or the symptoms, and then there's a source of insurance or other source to pay the claim. And those are the things we look at, and as we, in the weeks to come, we can focus on each of these elements a little bit more, and I hope be more helpful with that. So we're going to take another break here shortly. Again, I'm Mike McLeod, here for all the lawyers with Kerrigan, Estes, Rankin, McLeod, and Thompson. We're a regional law firm that represents people who have been seriously injured in accidents and folks that have lost loved ones who were killed in serious accidents. We've been around for 40 years and we've hosted the law show for a long time. So thank you for watching and stay tuned for more of the law show.
For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida.
Welcome back to the Law Show. Bob Kerrigan. I was discussing the state grand jury and intended to go on and talk about the federal grand jury at a later show, but let me just be more complete in my description of the grand jury situation. So it is try to be entirely fair about it. The United States Supreme Court, looking at the function of the grand jury, has justified the existence of the grand jury and cited these reasons. Again, I'm quoting from this article from Greg Thomas, Carol Jean LaCicero, and Linda R. Norbutt, published in the Florida Bar Journal. I thought they did a good job. So here's what the United States Supreme Court has said about grand juries and their secrecy. A lot of people criticize what's going on in the grand jury because, in fairness, to the critical of it is the prosecutor gets to tell the grand jury whatever the prosecutor feels like telling the grand jury. Okay, and the system depends on the integrity of the prosecutor. As long as you have a prosecutor of integrity, your system is working pretty good. But there's nobody in there that's looking out for the person being accused of a crime. There's absolutely, you can't have a lawyer present. So grand jurors are just hearing one side of it, but all they're doing is returning an indictment. I mean, they're not finding a person guilty and sentencing him, that sort of thing. So the argument is, well, all they're doing is an investigation. There are reasons why the grand jury is used. So I'm going to read these to you from the Supreme Court, kind of a summary from this article. One, the fear that the witnesses will not come forward voluntarily in their identity if their identity is not protected. That's one reason. Two, the fear that witnesses will be less likely to give full, frank testimony if their identity is known, so they will become subject to retribution or inducements. I think that's particularly true when they were investigating organized crime. The risk that the indicted will flee if indictments are made public prior to arrest. That's a very good reason to do it in secret. You get the charging document ready, the charging document gets sent, and before the charging document is filed, the arrest of the defendant takes place. The danger that a potential defendant might influence the votes of grand jurors, corruption again going back to organized crime, and the protection of the reputation of an individual who is accused but not indicted by the grand jury. So all of those were reasons that the United States Supreme Court determined that the grand jury was a valid and important part of our system. I agree with that. I think where suspicion has arisen is because it is all private, it's all secret. I think there's this case in Kentucky with this young woman that was killed, Taylor, where the grand jurors are now talking about the fact that the prosecutor didn't give them any choices or didn't give them adequate choices about what they could do with the information, didn't present the potential charges that could be filed. So the problem with the system, and no system is perfect, but the problem with the system is that no one knows what goes on in there but the prosecutor. What's the solution? Elect good prosecutors. We've had great prosecutors here, and Curtis Golden, Bill Edens, and so you depend on their integrity for the system to work. Where you have problems develop is where you have people elected as state attorneys whose integrity is questionable. Then the grand jury process can be really, really abused. That's the potential harm for it, and it's like anything else in this country. You want to avoid the problems, elect good people to public office. Speaking of that, it's so difficult for good people to want to run for public office. Almost the second you declare for public office, there is a relentless assault by the opposing side. It's not particular to one party or another. They're both bad, both terrible, actually. And just ruinous statements can be made about a person, about their family, about their reputation, about their achievements in their life. It makes most people very leery about running for public office just because of what happens. So what do you get a lot of times? You don't get the cream of the crop. That's a fact now. You get sometimes good people that are elected public office, but a lot of times you don't. You get crackpots and showboats and people that have ulterior motives and on and on and on and on. Because they're the ones who want to run for public office. Again, exception, there are good people, obviously. who get elected for public office. We had one great governor here, Reuben Askew, one of the great people in Florida, Leroy Collins and others. We've had wonderful governors in Florida in the past. So the issue is electing good people. Like I said, the prosecutors are no different. Elect good prosecutors. And I understand we've got a wonderful young woman going to be a prosecutor in North Florida now, who will replace Bill Edens. And so we wish her the best and hope that she does well in her work and that she does not allow the abuse of the grand jury. And we feel sure she will not. Some time ago, I mentioned on one of the programs we're going to talk about the disparity in racial and ethnic fetal deaths. It was alarming to me when I read it, so I'm going to refer you to some more information about this now. And there is a report called the MMWR, that's the Morbidity and Mortality Weekly Report from the FDA. And they do wonderful work. The FDA has a great reputation, and in the past, I think lately they've been assaulted some because of the COVID-19 virus, but overall they just have had a splendid reputation as a governmental agency dealing with the nation's public health, and applaud them for that. This study was done in 2015 to 2017, and during 2015 to 2017, I'm reading from this report now, and I'm not sure what the date of this is, but the time period covered was 2015, 2017. A lot of times the data is older and it's not really analyzed in depth, for a couple of years. So this is not that unusual to have it for a time period of 2015 to 2017. The fetal mortality rate among non-Hispanic Black women was more than twice that among non-Hispanic white women and Hispanic women. Fetal mortality rates varied by state. Of course they do. And cause of death category. Makes sense, okay? Some states have better health care. Some states have more poverty. It just depends. The rate of fetal deaths attributed to maternal complications among non-Hispanic Black women was 3 times that among white women. All right, now what you have to avoid in trying to understand this data is stereotyping why you think it might have happened. We don't know fully. There's all kinds of factors, and this report goes on to explain you have a much higher rate of fetal mortality, less than 20 years old, and over 40 years old. So in that range of 20 to 40 is the best time, obviously, to conceive and have a child. Earlier than 40, you have higher fetal mortality, and above 40, you have higher fetal mortality. During this period of 2015 to 17, the United States fetal mortality rate was 6 per 1,000. That's 6 deaths per 1,000. I want to explain something. In Florida, the concept of a death is very misunderstood. Despite claims by all kinds of politicians about how they're so pro-family or pro-whatever they are, pro-life or whatever, the law in Florida, which has been a law for some time, they refuse to change it, is that a full-term baby in the mother's womb is not considered a human being until the baby is born. And so if some negligent act causes the death of that baby in her mama or his mama, it's not considered a death. It's considered an expiration of a fetus, and it is not referred to as a baby death. And so there's a real misunderstanding about that in Florida. You would think that every church in Florida, every church in North Florida especially, would be outraged to hear this. Just outraged. But yet it's been the law, will be the law, and this legislature will never change that law, to recognize a life at conception. They're not going to do it. They don't recognize a life at 9 months, a full-term baby in her mama at 9 months. They do not recognize it as a human being, period. And so if that fetus dies, it's considered a death of the mother's tissue. It's not considered a death of a human being. And of course it's wrong. Of course it's championed by the medical profession and by obstetricians. Of course they favor that. The public should be opposed to it. I think if you took a poll, you'd find 80% of the people are opposed to that. It's outrageous that a 9-month carry of a baby called a fetus, because it's not born yet, is not considered a human being for purposes of the Florida wrongful death statute. Not considered, period, no matter what. And the fact that it isn't is really troubling. But I'm back to the fetal mortality information here that I'm reading to you. It's 6 per 1,000 live fetal deaths. Among Black women, the fetal mortality rate is 11.2. More than twice as much. More than twice that among white women, they're at 5.0. And Hispanic women, 5.1. And the rate among mothers aged less than 40 years was also significantly higher than among mothers aged 20 to 39 years. That's for Black women. Fetal mortality among women who had multiple gestational pregnancies, was more than twice that of mothers carrying single babies. The fetal mortality rate varied by U.S. state. Overall rates were higher in the southern United States. We're not surprised about that. Alabama reported the highest rate. Now, what's puzzling about that? I mean, if anybody knows anything about Alabama would say that's probably right. Alabama reported the highest state-level fetal mortality rate among white women and Hispanic women. Fetal mortality rates among Black women exceeded 16 per 1,000. Now, to avoid a stereotypical response, well, that's, because they're having babies too young or this, that, they're not married or whatever. We don't really understand this. We know it has something to do with health care. There isn't any question about that. You see it's worse in some states than it is others. But we need to know more about it. Now, this is an inequality that can be objectively determined and objectively analyzed and objectively discussed. And we hope it will be. You're watching The Law Show. Bob Kerrigan with you. I'm one of the lawyers at Kerrigan, Estes, Rankin, McLeod, and Thompson. We specialize in personal injury and death cases, medical malpractice cases, and cases involving serious injury or deaths, and we've done it for decades. We have all board-certified lawyers in the firm. Your case will be addressed and handled by a board-certified lawyer. So we hope you'll contact us before you make a decision, and we'll see you next week on The Law Show.